So while the police obviously live under the criminal rules of procedure, where the evidence threshold is 95% beyond a reasonable doubt in criminal court, these are the juvenile rules of procedure. This is juvenile court, where the burden of proof is much lower. It dips from 95% down to 51%, or a preponderance of evidence. Now, there are some states like Pennsylvania, I believe, where the evidence threshold is 75%, clear and convincing evidence at the adjudicatory or evidentiary hearing or trial. That, again, is your day or days for the accused to prove a negative innocence, to introduce evidence, witness testimony, fact witnesses, expert witnesses, exhibits, to basically impeach the allegations against you. There was a provision where an attorney may cajole you, the accused, to consent to dependency, again, to basically admit that you made a mistake or you were wrong, you committed perhaps a lesser type of abuse, but you did commit abuse, perpetrate abuse, and perhaps the judge will go easy on you, where the child will come home after you sign a case plan, and you have to jump through the hoops of CPS. Now, there are two types of plans, if you will. So at the initial stage, when CPS does knock on that door of your home or business, there's a risk safety plan. I don't recommend you sign that, just like I don't recommend you talk to CPS without a lawyer present. In fact, in Iowa, these risk safety plans have been ruled unconstitutional. There was a 2014 case where a federal judge ruled CPS's execution of risk safety plans to be unconstitutional. Now, those risk safety plans, CPS again will get you to try to jump through a few hoops to remedy what they believe are wrongs that you committed in order to hold on to your child in the home or get the child back. That's a promise from CPS. I wouldn't want them to, I would want to contest them. I just, you have to challenge at every fork in the road, because they're going to challenge you, the accused. I can assure you, I get challenged all the time in cases. You have to challenge them, and I don't know that I would trust them. Okay, so that's the first plan, or is a risk safety plan. The more in-depth plan is called a case plan. And the case plan comes to fruition if you lose at the dependency stage of litigation, whether you lose at trial or whether you consent to dependency, either or, the judge will force you to sign that case plan. And that basically gives CPS and the accused 15 to 22 months. 15 to 22 months time frame under the Adoption and Safe Families Act from 1997 for the accused to substantially comply with that case plan, meaning you have to successfully jump through those hoops. Those hoops could contain a parenting course, a psychological evaluation, therapy. It could be a sundry of tasks that the accused has to perform and do so successfully in order to meet the threshold of substantially complying with that case plan. So, because there are two judicial review hearings, there are judicial review hearings at the 6-month time frame post dependency. So, let's say you have your hearing coming up here in March of 2024, but you lose. You basically have till March of 2025. After two judicial review hearings, 6 months apart, to substantially comply. And if you did not do so by that time frame, CPS has the right to file a petition for termination of parental rights. So they are escalating the case from dependency to what's called TPR. At that stage of litigation, they are required to prove their case by clear and convincing evidence. Okay. And so therefore, the burden of proof is a little higher for CPS at that stage, about 75%. But if they are successful, then you have lost your parental rights and you have to appeal, and appeals are very expensive. You could obtain an attorney, perhaps at no cost, just like you could obtain an attorney for the dependency stage of litigation. You could obtain a appellate attorney under the rules of juvenile appellate law. That's even more complex than at the dependency litigation stage.